In June 30th, 2021, 42-year-old Gaddafi Allah was exonerated in Kings County, New York of the attempted aggravated assault of 3 New York police officers shortly after midnight on New Year's Eve in 2000. Allah, who had been released on parole in 2018, said his exoneration by the Kings County District Attorney's Conviction Review Unit showed that justice was provided and served today, but it hurts that I had to go through so much. His ordeal began at about 12:15 a.m. on January 1st, 2000, when Allah was 20 years old and known as Philip Almeida. He was among a group of people watching fireworks when 4 plainclothed New York police officers stopped to investigate someone firing a revolver into the air in front of 1320 Eastern Parkway in Brooklyn. The officers shot at the young man and said that Almeida then began firing a semi-automatic pistol at them from behind a brick wall in front of the residence. 3 of the officers took cover and returned fire. Seconds later, Almeida came out with his hands in the air. He was arrested immediately. Officers went into the building and arrested the 16-year-old youth, identified as MH. 2 of the officers, Sergeant Charles Broughton and Officer Patrick Coward, identified Almeida on the scene as the man who shot at them. The other 2 officers, Detective Sidney Straubert and Officer William O'Brien, identified Almeida in a photo lineup as the shooter. Detective John Landino interviewed Sergeant David Cheesewright, who arrived at the scene after the shooting. Landino's handwritten notes said that as Almeida was being handcuffed, Cheesewright heard him say about 4 times, "I'm gonna kill those obscenity." However, Landino's typewritten report quoted Cheesewright as saying that Almeida said, "I hate you cops. I should have killed you obscenity." Detective Samuel Guilford from the Police Crime Scene Unit recovered 26 spent shell casings on the sidewalk and by the entrance to a walkway leading to the building. He also found 2 live bullets on the sidewalk. Behind the brick wall on either side of the walkway were separate courtyards that were each fenced in and separate from each other. A 9mm semi-automatic pistol was recovered in the left courtyard inside a cement planter box. A cartridge was in the chamber of the gun with a cartridge jammed behind it, and there was another cartridge in the magazine. The officers said Almeida ran out from the courtyard on the right side of the walkway. Almeida and MH were each charged with 4 counts of attempted murder, 4 counts of attempted aggravated assault of a police officer, and 1 count of criminal possession of a weapon. Ultimately, the indictment against MH was dismissed, and in April 2000, he pled guilty as a youthful offender to possession of an imitation pistol. Prior to trial, Almeida took a polygraph examination and was said to be truthful when he denied possessing or firing a gun. In January 2001, a pre-trial hearing was held in Kings County Supreme Court on a defense motion to bar the prosecution from testifying about Almeida's statements when arrested. Sergeant Broughton testified that when he and the officers pursued MH, who ran into the house, they were met with gunfire coming from the courtyard on the right. He said he saw Almeida shooting, and he fired back. Broughton said he and his fellow officers were pinned down. Broughton said Almeida fired 4 volleys of rapid-fire shots, and there was a delay. At that point, Broughton said he and Detective Straubert jumped into the walkway. Broughton said Almeida jumped out from some bushes with his hands in the air, yelling, "I hate you police. I wished I had killed you obscenity. I hate you." Broughton said he and Straubert grabbed Almeida and turned him over to uniformed officers who had arrived. Broughton said Almeida kept talking all the way through, yelling and screaming how he hated the cops, how he wished he had killed them. The defense motion was denied, and in February 2001, Almeida went to trial. In opening statements, the prosecutor told the jury it was a simple case and quoted Almeida as saying, "I hate you cops, and I should have killed all you obscenity." The prosecutor noted that 9 or 10 recovered shell casings were linked to the gun recovered at the scene in the planter. All 4 officers testified and identified Almeida as the gunman. They described how he fired volleys of rounds. O'Brien identified the gun found in the planter as the gun that Almeida was firing. Broughton, Straubert, and O'Brien testified that they heard Almeida say he should have killed the officers. Detective Guilford, the crime scene officer, testified that he attempted to lift fingerprints from the gun recovered from a planter, but he did not find any prints of value. He said he recovered 26 shell casings and 2 live bullets, all from the sidewalk outside the brick wall at the front of the property. Detective Sean Hart, an expert in firearms analysis and examination, examined the recovered pistol and the 3 cartridges in it. Hart tested 2 of the cartridges and determined that the gun and ammunition were operable. Hart told the jury that the magazine of that gun held up to 21 cartridges. Each time the trigger was pulled, a bullet was fired, the cartridge was ejected, and a new cartridge entered the chamber from the magazine. Detective Joseph Ramirez, an expert in microscopic comparison and firearms operability, testified that the officer's guns and the recovered gun were all 9mm semi-automatic pistols. Ramirez determined that 16 of the recovered shell casings had been fired from 3 of the officer's guns. 9 other recovered shell casings had been fired from the 9mm gun recovered from a planter, he said. Ramirez was cross-examined about whether he could determine where the officers and the shooter were positioned based on the location of the recovered shell casings. Ramirez testified that there was no way to determine their positions without knowing the direction of fire and the way the guns were held. He explained that if the gun were held straight out, perpendicular to the body, and in the right hand, the casings would go over the right shoulder and land 5 to 10 feet behind the shooter. Thus, he said, the shooter would be positioned anywhere within 5 or 10 feet of where the casing landed, assuming the casing stopped where it landed and did not move. But casings are round and cylindrical and tend to bounce and roll. Also, there were many variables that affected the distance the casings traveled after ejection, such as whether the shooter held the gun at a different angle and to the side, and even the firmness of the shooter's grip on the gun. Almeida's defense attorney called a Sim Jones as a defense witness. Jones testified that on the night of the shooting, he was part of a group watching fireworks over Grand Army Plaza at the main entrance to Prospect Park. He said there were at least 15 people present outside, including Almeida and Almeida's brother Michael. There were others, including M.H., who were inside the building. Jones said that Lamont Hunter, who lived on the same block, came to watch the fireworks carrying a black bag. Hunter took a gun from the bag and shot into the air. Jones said Hunter reloaded and fired more shots just as the officers jumped out of an unmarked vehicle and yelled for everyone to freeze. Hunter then ran into the house, Jones said. Jones told the jury the officers began shooting and that no one was shooting back at them. Jones said that several people ran inside, while others dropped to the ground. Several people from the 2 courtyards, as well as from inside the house, were taken to the police station, though only M.H. and Almeida were charged. Jones said he did not recall Almeida ever saying that he hated the police or should have killed them. Hector Hunt, who was Almeida's best friend, said that he was present when Hunter let off a couple of rounds. Police then arrived and started shooting, Hunt said. He said he ran inside while Almeida and his brother and others remained outside. Hunt said that the only person with a gun was Hunter and that he thought it was a semi-automatic. Michael Almeida testified that when Hunter and his pregnant girlfriend showed up, Hunter took a gun out of a bag and began firing it into the air. Michael said he grabbed his brother to get out of the way. At that point, the 4 officers emerged from the vehicle and began shooting. Michael said that when his brother attempted to cross the street, the officers grabbed him. Charles Donovan, who lived in the building where everyone had gathered, said that Hunter had fired about 10 shots, aiming into the air and toward Grand Army Plaza. At that point, the vehicle containing the officers pulled to a stop on the median. The officers got out and began firing. Donovan said no one fired at the police. Donovan testified that when he learned that Philip Almeida had been charged, he went to the police station a day or 2 later and reported that Hunter was the only one who was shooting. The defense did not question the firearms examination evidence. On February 28, 2001, the jury acquitted Almeida of 4 counts of attempted murder, as well as the charge of attempted aggravated assault of Detective Straubert. He was convicted of attempted aggravated assault of Broughton, Coward, and O'Brien. On April 5, 2001, Almeida told the judge he was innocent before being sentenced to 21 years in prison. On appeal, Almeida argued that since semi-automatic shell casings are ejected from the side of the weapon, the shooter could not have been in the courtyard where he was because the casings were recovered from the sidewalk. Almeida also argued that the gun was recovered in the left courtyard and that he was in the right courtyard. In August 2004, the Appellate Division, 2nd Department of the Kings County Supreme Court rejected these arguments and upheld Almeida's conviction and sentence, noting that the testimony of the officers provided a sufficient factual basis to support the convictions. Inconsistencies regarding the location and source of shell casings that fell during the gun battle were placed before the trier of fact and resolved in the prosecution's favor, the court held. In April 2018, Almeida, who by then had changed his name to Gaddafi Allah, appeared before the New York State Board of Parole. He maintained his innocence, and his parole was denied. At that time, Allah was informed he would not get another parole hearing for a year. However, on December 17, 2018, he was released on parole. On June 30, 2021, Allah was exonerated, his convictions were vacated, and the charges dismissed following an investigation by the Kings County District Attorney's Conviction Review Unit (CRU). A reinvestigation of the evidence, including an analysis of the firearms evidence by an outside expert, Dr. Michael Knox, showed that the officers had testified falsely to implicate Allah, according to District Attorney Eric Gonzalez. The integrity of the defendant's conviction was undermined by the officer's implausible trial testimony that the defendant possessed the recovered gun and shot at them from inside the courtyard, and upon apprehension, made an inculpatory statement evincing his intent to kill the officers, the CRU said in a 31-page report. Knox, a crime scene reconstructionist with expertise in firearms and ballistics, concluded that based on the location of the shell casings and cartridges of the recovered gun, it was highly improbable that they came from the courtyard where the officers said Allah was. Knox said it was more likely the casings and cartridges came from a gun fired by Hunter the man, who defense witnesses at Allah's trial testified was firing a gun after midnight. As part of the reinvestigation, the CRU interviewed Detective Guilford, the crime scene officer. Guilford recalled that he had not been told that the shooter was in the courtyard. When informed of the officer's testimony and asked if it was plausible based on where he found the shell casings, Guilford said, "No." The CRU report noted that for the 9 shell casings linked to the recovered gun to wind up on the sidewalk outside of the fence at the front of the property, they would have had to bounce through shrubbery, a chain-link fence, and over a 2-foot-high brick wall, or somehow work their way through the small square holes in the brick wall. The likelihood of that event occurring for all 9 shell casings is so remote as to be virtually impossible, the report said. The report noted that inexplicably, Allah's trial defense attorney failed to question the prosecution's firearms experts about how the shell casings could have wound up on the sidewalk. The CRU concluded that not only was the officer's testimony about seeing Allah with a gun not credible, but that the location where the gun was found, the planter in the left courtyard, contradicted the officer's testimony that Allah was shooting from the right courtyard. The CRU said that the officer's initial accounts of Allah's statement after being arrested, including the version in Detective Landino's notes, suggest that the defendant never made the inculpatory version attributed to him at trial. The CRU noted that the prior inconsistent versions from the officers were known to Allah's defense lawyer, but the lawyer inexplicably failed to confront the officers with their prior versions. The CRU believes that the case should not have proceeded without the prosecution fully evaluating the evidence, including the ballistics evidence, particularly the location of the discharged shelling casing that made it to the recovered firearm, Officer O'Brien's identification of the recovered gun, and the officer's final trial version of the defendant's statement effectively admitting his intent to kill. The prosecution embraced the evidence without analysis, examination, or consideration of any of these issues, the CRU report said. This was the result of confirmation bias, the tendency to unconditionally embrace information that supports existing beliefs or reject information that contradicts those beliefs. For prosecutors, such bias is particularly toxic, the report said. Finally, the CRU said it has no confidence in the integrity of the conviction, and there is no reliable, credible evidence of guilt. On June 30th, following a motion by Mark Hale, head of the CRU, Kings County Supreme Court Justice Matthew Demick vacated Allah's convictions and dismissed the charges. In May 2022, Allah filed a compensation claim in the New York Court of Claims. In June 2024, Allah filed a federal civil rights suit against the New York Police Department. In May 2025, the lawsuit was settled for $3.9 million. On August 1, 1984, the mother of a 4-year-old girl at a Bronx daycare center told the Bronx County District Attorney's Office that she had taken her child to a doctor who said the girl had been raped. Detectives quickly began to question other parents of children at the Bronx Daycare Center, operated by the Puerto Rican Association for Community Affairs. They heard complaints from a total of 10 children about being abused as many as 5 separate times. Some of the assaults allegedly took place in closets, others in view of other children and staff, and some away from the 3-story brick building that housed the center, where 150 students and 21 teachers and aides were present daily. The following day, police descended on the center and arrested Albert Algarin, 21, Herminia Albo, 60, and Jesus Torres, 29. Algarin, a teacher's aide, was charged with rape. Albo and Torres, both teachers, were charged with sexual abuse. By the following week, 60 children had been interviewed, and authorities said 18 of them reported being abused all by the same defendants. The case was one of a wave of allegations of child sex abuse at daycare centers across the nation that ultimately were shown to be the product of unreliable testimony from children produced by manipulative interviewing techniques by child welfare workers, therapists, and law enforcement. On September 20th, Bronx County District Attorney Mario Merola announced the indictments of Torres, Algarin, and Franklin Beecham, 27, a teacher at the center, on more than 100 charges of rape, sodomy, and sex abuse of children. The grand jury declined to indict Albo after she took and passed a polygraph examination at the request of her attorney and testified before the grand jury. They were tried separately in 1985 and 1986. Algarin went on trial in October 1985, and the girl who sparked the investigation testified via closed-circuit television that he had raped her. A medical expert testified that examinations of the victims revealed medical evidence pointing to sexual abuse. On December 8, 1985, he was convicted of 23 counts of the rape and sexual abuse of 5 children. On January 15, 1986, he was sentenced to 25 to 50 years in prison. At Torres's trial, Deborah Saunders, a sex abuse expert and pediatrician at Albert Einstein College of Medicine, testified based on her review of the medical records. She did not examine the children herself. She testified that 1 boy and 1 girl showed injuries consistent with sexual abuse. She said 2 other boys did not show signs of sexual abuse, but she claimed that statistics showed that only 1 in 5 sexually abused children show signs of abuse. Torres was convicted on March 19, 1986 of 3 counts of sodomy involving 2 boys and was sentenced to 25 to 40 years in prison. At Beauchamp's trial, a doctor testified about an examination of a male victim. The doctor testified that there was a skin tag at the anal opening. She testified that this was consistent with increased friction in the area and with penetration by a male penis. She conceded that the tag was also consistent with constipation, but she said that this was rare. She further testified that skin tags in the rectum that were not caused by abuse were rare. Medical records were introduced about a female victim who was 4 or 5 at the time of the incidents. The record stated that she allowed an examination of her vagina without a fuss, and that this was unusual for a child her age. Beecham was convicted on June 5, 1986 of 9 counts of rape, sodomy, and sexual abuse involving 2 boys and a girl. He was sentenced to 25 to 75 years in prison. On appeal, Beecham contended the testimony of the children was false and had been produced by improper interviewing techniques. On May 9, 1989, the New York Court of Appeals set aside Beauchamp's conviction. The court said that the indictment against Beecham was so vague, it was virtually impossible to prepare a defense. Thus, defendant's motion to dismiss should have been granted because the charges were duplicitous, the court said. On September 20, 1989, the charges were dismissed and he was released from prison. In 1990, Torres's conviction was set aside by the trial court based on the decision in Beauchamp's case. The charges were dismissed, and he was released. Algarin's conviction was overturned in October 1990 on the same basis, and the charges were dismissed, and he was released. Algarin, Beecham, and Torres weren't the only Bronx day care workers to be wrongly convicted during this time. In 1984, Reverend Nathaniel Grady, the chaplain for the Yonkers Police Department, had indicted on charges of abusing 6 children, ages 3 and 4, over a period of several months in 1983 at the Westchester Tremont Day Care Center in the Bronx, New York. He was convicted, sentenced to prison, and his case was ultimately overturned. Also in 1984, 21-year-old Alberto Ramos, a college student working as a teacher's aide at the Concourse Day Care Center in New York City, was accused of raping a 5-year-old girl at the center. He was convicted and sentenced to prison. His conviction was vacated and the case was dismissed in 1994. In 1994, an investigation of sex abuse cases in New York City by CBS News raised questions about whether any of the abuse had happened and whether the allegations were the result of coercive and suggestive questioning the authorities. The CBS investigation revealed that each of the children had been questioned more than 80 times before trial. At one point, one of the children identified the trial judge as his molester. On June 22, 1985, an 11-year-old girl told police that she came out of the shower wearing only a towel in her home in the Bronx, New York, and saw a man in the hallway. She said she ran to a closet, but the man ordered her out at knife point and forced her to sit on a bed while he ransacked the apartment and then fled with 2 bags of valuables. 3 days later, the girl Leslie Carr, after viewing hundreds of photographs, selected the photograph of 39-year-old James Anderson in a photographic lineup. Police were unable to locate Anderson at first, but finally, in October 1985, Anderson was arrested and put in a live lineup. At the time, Anderson had one of his eyes heavily bandaged, the result, he said, of being struck with a baseball bat in a fight. So the other 5 participants also wore bandages over their eyes. Carr selected Anderson as the man who accosted her with a knife and burgled the apartment. Anderson was charged with robbery, burglary, grand larceny, criminal possession of a weapon, and endangering a child. Anderson was released on bond and was a fugitive for more than 2 years until he was arrested again in December 1989. He told his lawyer that he had been at a hospital methadone treatment center for several days getting treatment at the time of the burglary. The defense lawyer subpoenaed the records and in January 1990 requested a continuance because the records had not yet been received. The judge denied the request to delay the trial after the prosecutor reported that he had called the hospital and was told that there were no records of Anderson getting treatment there. On January 17, 1990, based on the identification of Carr, a jury convicted Anderson of burglary, grand larceny, criminal possession of a weapon, and endangering a child. The robbery charge was not submitted to the jury. Before Anderson could be sentenced, the records arrived and showed that Anderson was at the hospital at the time of the crime. Further, the prosecutor discovered that the hospital statement that there were no records of Anderson being treated referred to medical treatment and did not include methadone treatment. The records showed that Anderson had received methadone at a treatment center in Manhattan about 10 miles from the apartment where the crime occurred, and that Anderson was there at 11:32 a.m. The victim's 911 call after the man fled the apartment was at 11:35 a.m. The prosecution obtained a record from that day bearing Anderson's signature. A handwriting analyst compared the signature on the document with exemplars of Anderson's handwriting and concluded Anderson had likely signed it. In June 1990, Anderson's attorney filed a motion to vacate the conviction and dismiss the charges. In July 1990, Anderson, who had been taken into custody after he was convicted, was released on bond. On August 14, 1990, the Bronx County District Attorney's Office concurred with the defense request. The convictions were vacated and the charges were dismissed. Anderson later sought compensation in the New York Court of Claims, but his claim was denied. On June 3, 1986, Stephen Shields, a New York City social worker, was fatally shot at the South Jamaica Houses public housing development in Queens, New York. The following day, police said they received an anonymous tip that the gunman was 41-year-old Eddie Andre, who had a prior conviction for manslaughter. Police brought Andre in for questioning, and he denied involvement in the crime. However, two 13-year-olds, Yvonne Hall and James Robinson, who were near the scene at the time of the shooting, selected Andre's picture from a photographic lineup as the gunman, although the photograph was of Andre when he was 20 years younger. Andre went on trial in 1988 in Queens County Supreme Court. Hall and Robinson identified him as the gunman. Andre told the jury that he was home watching a professional basketball game with a friend. A mistrial was declared when jurors deadlocked 11-1 in favor of acquittal. Andre went on trial a second time in October 1988. Hall again identified Andre as the gunman, but Robinson testified that he had not seen the shooting at all. The prosecution, over defense objection, was allowed to introduce Robinson's testimony at the first trial when he said he saw Shields and Andre quarreling, and then Andre shot Shields. On November 1, 1988, a jury convicted Andre of second-degree murder and illegal possession of a firearm. He was sentenced to 25 years to life in prison. Andre's 64-year-old mother, Roland, who worked as a tailor in a dry-cleaning business in Queens, believed her son's claim that he was innocent and began a quest to find Hall and Robinson. During the next 3 years, she interviewed scores of people, often in housing projects with high crime rates, and spent hundreds of days trying to find the witnesses. She showed photographs of her son to more than 200 people. One day, by chance, Robinson walked into the dry cleaning business and disclosed that he had been a witness against her son. He admitted to Roland that he had not known if Andre was the gunman when he selected his photograph in the lineup. Roland later located Hall's grandmother, who agreed to arrange a meeting with Hall. At the meeting, Hall admitted that she could not say Andre was the gunman. Both Hall and Robinson signed sworn statements, recanting large portions of their trial testimony. Later, in court, Hall recanted her recantation and said that in fact Andre was the gunman. In July 1992, the Appellate Division of the New York Supreme Court reversed Andre's conviction and ordered a new trial. The court held that the prosecution should not have been permitted to introduce Robinson's entire testimony from the first trial, and that the prosecution made an improper closing argument to the jury. Andre was released on bond pending a retrial. In October 1994, the Queens County District Attorney's Office dismissed the charges. At 10 a.m. on April 26, 1993, 3 men wearing dark suits bearing identification tags knocked on the back door of the home of Hilda and Olga Vargas in Queens, New York, and said they were boiler inspectors from the city of New York. When Olga Vargas refused to allow them inside, one of the men drew a gun and they forced their way inside. They demanded to know the location of a safe. 2 of the men went to the basement where they found Betsy Rodriguez, a friend of Olga Vargas, who was staying with the family. The man still upstairs took Vargas to her bedroom. He said that they had kidnapped her husband Hilda and would kill him if she did not reveal the location of their safe. Vargas then emptied a safe that was in the bedroom and turned over its contents, including $10,000 in cash and some jewelry. After saying that they knew where her children went to school, the men said they would return and kill the women if they called police. After the 3 men left, Vargas called her husband, who came home and called police. On May 5, 1993, Olga Vargas and Rodriguez viewed a lineup and identified Jose Marte as one of the 3 robbers. 2 days later, Hilda Vargas received a phone call from a man speaking Spanish with a Dominican accent. The man said that if Olga Vargas testified before a grand jury, the entire family would be killed. Another similar call was made on May 10th. At 1:15 a.m. on May 11th, the day before Rodriguez and Olga Vargas were scheduled to appear before the grand jury, the Vargas' home was sprayed with bullets. The bullets shattered windows in the front of the house, the porch, the Vargas' bedroom, and 1 bullet pierced the wall of their child's bedroom. On May 12, 1993, police arrested Luis Morales in his apartment and recovered 8 spent shell casings. Police later said that at least 1 shell casing found at the Vargas home was similar to the casings recovered from Morales. Later that day, Rodriguez and Olga Vargas identified Morales in a police lineup as one of the men who forced their way into the home on April 26th. On December 1st, 1993, the FBI, acting on a tip from a confidential informant, arrested 37-year-old Robert Angeles Acosta, who had emigrated from the Dominican Republic, on an unrelated matter. In his wallet, the agent found a pawn ticket from a Bronx pawn shop. Subsequently, Vargas's husband viewed the items at the pawn shop that were in Angeles Acosta's account and said that some of the jewelry was his that had been taken on the day of the robbery. On August 4th, Olga Vargas viewed a lineup and identified Angeles Acosta as the third man involved in the robbery. Rodriguez did not view the lineup. In April 1995, Angeles Acosta, Marte, and Morales went to trial in Queens County Supreme Court. Olga Vargas and Rodriguez identified them as the three robbers. Hilda Vargas said some of the jewelry recovered from the pawn shop was part of the jewelry stolen from the safe. On May 19, 1995, the jury convicted the men of attempted murder, robbery, burglary, criminal possession of a weapon, and tampering with a witness. Morales was sentenced to 20 to 40 years in prison. Marte was sentenced to 12 to 25 years in prison. Angeles Acosta was sentenced to 16 and 2/3 to 50 years in prison. In 1998, the Appellate Division of the Supreme Court of New York, Second Department, upheld Angeles Acosta's convictions. He later filed a federal petition for a writ of habeas corpus, but that was denied in 2003. In 2008, Angeles Acosta wrote to Adele Bernhardt, who was running an innocence clinic at Pace Law School. A review of the case failed to turn up new evidence. However, 5 years later, in 2013, Morales filed an application for parole. At that time, he said that although he was guilty, Angeles Acosta was innocent. Morales signed an affidavit that he submitted to the parole board. Morales told Bernhard that at the time he went to court after his arrest, he knew that Angeles Acosta was not involved. However, because Morales believed that Angeles Acosta was an informant, he said nothing. After Morales was granted parole, he went to the 106th Precinct Police Station in Queens and provided the name of the third person who committed the crime with him and Marte. Police directed him to the Queens District Attorney's Office. On February 15, 2018, Bernhard, accompanied by Morales, went to the Queens County District Attorney's Office and presented a prosecutor and 2 detectives with her report of the reinvestigation of the case, as well as the name of the third person involved in the crime, Ruben Sierra. During questioning, Morales said that the Vargas home was targeted because a relative of Olga Vargas told a taxi driver named Luis Salazar that drugs and cash were kept there. Morales said that he, Salazar, Sierra, and Marte planned the robbery of the home, but when Salazar failed to respond to a page on the day it was planned, so only Morales, Sierra, and Marte entered the home. Morales said that even though they were led to believe that there was upwards of $10,000 in the home, the jewelry collected barely made up $1,000. He said that Sierra drove them to Chinatown where they sold off the jewelry. Morales said that at Marte's urging, he and Salazar and Sierra drove by the Vargas home and fired 12 shots into the home. Morales said that he recalled that when he first met Angeles Acosta in custody, Angeles Acosta was complaining about not knowing why he was there. Morales said he didn't realize Angeles Acosta was charged in the same case with him and Marte until they were called into the courtroom. Morales said he told his attorney that he didn't recognize Angeles Acosta, and his attorney said they all say that. From that point on, Morales said he believed Angeles Acosta was working as a police informant. The prosecution began to reinvestigate the case. By that time, Marte was dead. In August 2019, attorneys for Angeles Acosta filed a motion seeking to set aside Angeles Acosta's convictions based on Morales' affidavit. On October 2, 2019, during a hearing on the motion, Robert Masters, an assistant Queens County District Attorney, said that the prosecution was requesting that Angeles Acosta's convictions be vacated. Masters noted that the third person named by Morales had been paroled not long before the crime for a different home invasion that involved the theft of 62 kilograms of cocaine. Masters said the third man fit the description given by Vargas and Rodriguez and noted that at the time of the crime, the witnesses said the third man had a beard. Sierra had a beard and Angeles Acosta did not. Morales took police-administered polygraph examinations and was deemed to be truthful when he denied Angeles Acosta was involved in the crime. Angeles Acosta also took a polygraph and was determined to be truthful when he denied involvement. The evidence presented at trial against the defendant regarding these matters was strong, and it's the view of the people that at that time it merited conviction, Master said. However, based on the newly presented evidence from Mr. Morales, a careful review of the initial case, and a thorough reinvestigation of this matter, there is cause to conclude that that's no longer the case. Masters added that subsequent reinvestigation undermined the strength of the jewelry identification and failed to find any connection between Angeles Acosta and Morales and Marte. Justice Kenneth Holder granted the motion to vacate the convictions. Masters then dismissed the charges and Angeles Acosta was released. In October 2019, Angeles Acosta filed a claim for compensation with the New York Court of Claims. He settled the claim in December 2020 for $3,500,000. At about 3 a.m. on September 16, 2001, 35-year-old Kerry Green flagged down 2 police officers. He said that 3 black men had attempted to rob him and his friend, 37-year-old Gabor Muronii, as they walked away from the Sweet Cherry Strip Club in Brooklyn, New York. Green had a bloody knife, which he said he used to stab one of the attackers, but said he heard several gunshots after he fled. Police found Muronii lying on the street in a pool of blood near the Sweet Cherry Club. His wallet and watch were on the pavement nearby. 6 shell casings were found on the street. Minutes after Green said 3 black men attacked him and Muronii, a police officer heard a radio call about 3 male blacks wanted for assault and stopped Nicholas Johnson at 44th Street and 5th Avenue. Police drove Green there, and he identified Johnson as his attacker. Johnson was arrested, but was later released after Green said he was not completely sure and that if the guy did not have a stab wound, then this would not be the guy. Johnson did not have any stab wounds. At about the same time, a police officer en route to the crime scene was approached by James Ortiz at 42nd Street and 4th Avenue. Ortiz asked what had happened. When the officer noticed that Ortiz's hand was cut and he was holding a bloody napkin, he arrested Ortiz. Green was driven to that location and identified Ortiz as the man who attacked Muronii. Ortiz soon was released, however, when police decided he was not involved. Almost immediately after the gunshots, 2 police officers, Michael Monteverde and Ronald Saiz, who were at 42nd Street and 4th Avenue, saw a black Pontiac Grand AM speed past. Monteverde said he saw a white man in the rear passenger seat. The officers got in their car and followed the Pontiac to 455 42nd Street. As they pulled up behind the car, they saw 3 men get out and go into the building. They summoned backup support and waited outside. While they were waiting, they saw a man who was bleeding leave the building, get in the Grand AM, and drive away. When more officers arrived, they went into the building and followed a blood trail to apartment 1R. They entered the apartment and followed the blood trail to the bedroom of 21-year-old Vladimir Arroyo. Arroyo said he had been with Eddie Lorenzo and that Lorenzo had been stabbed. Police determined that Lorenzo lived in Staten Island and officers were dispatched to medical facilities there. Not long after, Lorenzo was arrested as he left St. Vincent's Hospital. He had stab wounds in his neck and head. At 5:25 a.m., police interviewed Green, who said that he and Muronii spent the evening eating pizza and bar hopping. Shortly before 3 a.m., they left Sweet Cherry and walked down 42nd Street toward 3rd Avenue. As they passed an idling parked car with dark windows, they realized that they went the wrong way and turned back. As they passed the idling car again, the front passenger window lowered and a man yelled, "Do you have a problem?" Green said he and Muronii said they didn't and kept walking. The car squealed its tires as it backed up and stopped near them. Green said that 3 black men got out of the car with guns and demanded their wallets and valuables. He said a tall man from the back seat of the car approached him while the driver and a short man from the front passenger seat confronted Muronii. Green said he took a knife from his pocket and opened it behind his back. The taller man demanded his wallet, and when Green tried to walk away, the man hit Green in the head twice with a pistol. At that point, Green said he began stabbing the man. Green said he then ran off and heard several gunshots behind him. Detectives interviewed Lorenzo and Arroyo separately. Detective Robert Keating reported that Arroyo told him that he and Lorenzo were at Sweet Cherry, and as they were leaving, a Russian dude brushed against Lorenzo, and Lorenzo fell towards a table. Lorenzo glared at the man, but Arroyo said he told him to let it go, and they left. Arroyo said that when they got to Lorenzo's black Pontiac, they saw the two Russian guys walking up the street. Arroyo said he and Lorenzo got into Lorenzo's car. They drove past the two men and then backed up very quickly. Arroyo said Lorenzo yelled, "What's up now?" and then grabbed a handgun from the left side of the car. Arroyo said that he and Lorenzo got out of the car. Lorenzo ran toward the two men and hit one of them in the face with his right hand. That man pulled out a knife, repeatedly stabbed Lorenzo by the neck, and then ran away. Arroyo said that the other man turned and Lorenzo fired at least 6 gunshots. Arroyo said that by that time, he had gotten back into the car. He said Lorenzo jumped in the car and drove off, yelling at Arroyo for not helping him. Arroyo said they drove to his family's apartment and went to his bedroom, where they tried to stop the bleeding from Lorenzo's wounds. About 10 a.m., detectives interviewed Lorenzo, who said that 2 white guys bumped into Arroyo at Sweet Cherry. When they were driving away, they saw the same 2 men from the strip club walking by. Lorenzo said Arroyo got out and began to fight with Muronii. When Green joined the fight, Lorenzo said he got out, but Green stabbed him. That's when Arroyo pulled out a pistol and fired several shots, Lorenzo said. After obtaining statements from Arroyo and Lorenzo, a police officer who had been at the hospital when Muronii was pronounced dead came to the police station. He reported that a physician said Muronii died of a stab wound to the chest. At 12:45 p.m., Detective Keating interviewed Arroyo a second time. He reported that Arroyo spontaneously said he wanted to correct his statement. The detective later said that Arroyo now said he was carrying a knife when they went to the club. He said that Lorenzo saw a Russian guy wearing a chain on his neck, and he decided he wanted the chain. The detective said Arroyo said that they saw the Russians and that Lorenzo yelled, "What's up now?" He said Lorenzo backed up the car rapidly and grabbed a pistol from the left side of the driver's seat, and they both got out of the Pontiac. The detective said Arroyo said he approached one of the men Muronii and demanded his property, while Lorenzo confronted the other man. Muronii took off his watch and dropped his wallet in the street. When Muronii advanced toward him, Arroyo stabbed him in the upper chest. Arroyo said that Lorenzo was hitting the other man, Green, when the man pulled out a knife and stabbed him. Arroyo said Lorenzo then fired several shots. Arroyo said they drove off and that he threw the knife out the window. The 2 statements were not recorded, but not long after, Arroyo repeated the statement on video. In the video, Arroyo demonstrated with his left hand how he stabbed Muronii and placed his right hand on his own upper chest to show the location of the stabbing. He said he felt like shit and that he did not want any of the property, so he threw the chain and Muronii's wallet and watch on the street. Police asked Green to view 2 lineups, one containing Lorenzo and the other containing Arroyo. In the first, he identified Lorenzo as the man who attacked him and the man he stabbed. In the second, he was unable to identify Arroyo as being involved. Officer Monteverde also viewed the 2 lineups. He identified Arroyo and Lorenzo as the men he saw leave the Pontiac and go into the apartment building. He said Lorenzo was the man who was bleeding and later left the building. About 5:52 p.m., detectives re-interviewed Green, who now said there were only 2 men involved, and that the smaller of the 2 went after Muronii, while the larger man attacked him. Lorenzo was a dark-skinned Hispanic, 5 feet 10 inches tall, and weighed 270 pounds. Arroyo was a light-skinned Hispanic, 6 feet tall, and weighed 200 pounds. Arroyo and Lorenzo were then charged with murder, attempted robbery, assault, and illegal use of a weapon. The following day, an autopsy was conducted on Muronii. The medical examiner determined that Muronii had not been stabbed. In fact, he had been shot in the back. The exit wound on his chest was a slit which apparently had prompted the emergency room physician to say he had been stabbed. The Kings County District Attorney's Office proceeded with the case even though Arroyo's confession detailed account of how he stabbed Muronii to death was contradicted by the autopsy. In November 2002, Arroyo went to trial in Kings County Supreme Court. The prosecution told the jury that Arroyo's statement about stabbing Muronii was an attempt to minimize his involvement, that he had acted in self-defense, and that in fact he had shot Muronii. Green testified and now said that he only saw two men get out of the car and neither was black. He identified Lorenzo as the man he stabbed after being pistol whipped. Green could not identify Arroyo as the second man. Arroyo's defense lawyer attempted to undercut his testimony by questioning him about a prior conviction for hindering a prosecution. Green claimed he had been forced to drive a friend who was wanted by authorities out of an upstate New York county to avoid arrest. Officer Monteverde testified and said for the first time that he saw Arroyo through an open window of the Pontiac as it drove past him. He also now testified that only two, not three, men got out of the car in front of Arroyo's apartment building. Detective Robert Keating testified that Arroyo volunteered that he wanted to change his statement. According to Keating, Arroyo said he left some things out and had not told the entire story. Keating denied that he fed any information specifically that Muronii had been stabbed to Arroyo. Although Keating said he told Arroyo that one person had been shot and one person had been stabbed, he testified that he did not say that Muronii had been stabbed. Keating read Arroyo's initial statement to the jury, and a video of Arroyo making his final statement was shown. On November 25, 2002, the jury convicted Arroyo of second-degree murder, 2 counts of first-degree attempted robbery, and second-degree assault. At sentencing, Arroyo, asked if he had anything to say, apologized to Muronii's family and friends for their tragic loss. However, he added, "I do want you to know, Your Honor, that I'm not guilty of the charges I was convicted of." Justice Gustin Reichbach sentenced Arroyo to 20 years to life in prison. On January 27, 2003, Lorenzo pled guilty to first-degree attempted robbery. He was sentenced to 9 years in prison. In 2007, the New York Appellate Division upheld the convictions. In 2008, Arroyo filed a federal petition for a writ of habeas corpus. The petition was denied in 2010. In 2017, Arroyo's trial defense lawyer, Jay Goldberg, asked attorney David Citron to re-examine the case. Citron subsequently asked the Kings County District Attorney's Office Conviction Review Unit to reinvestigate. On February 23, 2019, District Attorney Eric Gonzalez issued a 43-page report of the CRU investigation and filed a motion to vacate Arroyo's convictions. Justice Matthew Demick granted the motion and the charges were dismissed. Arroyo was released from the courtroom. The CRU report said that the reinvestigation uncovered several errors, which raised serious concerns about the integrity of the conviction. The report noted that the only direct evidence of Arroyo's guilt was his purportedly spontaneous confession, which was consistent with a false fact law enforcement believed to be true at the time defendant confessed, that the deceased had died of a stab wound to the chest, and which must have been supplied by the interrogating detective. The report said that Detective Keating's reports, statements, and testimony concerning how the false confession originated can be characterized at best as incomplete and at worst false and deliberately misleading. The report also said that the prosecution had failed to disclose detective notes about Green's identification of James Ortiz as the attacker of Muronii. The notes also said that when Ortiz was stopped with a bleeding hand, he was with 2 others. The failure to disclose the notes may have deprived Arroyo of the opportunity to rebut the prosecution and advance a viable theory of defense. In addition, detective notes reporting that Officer Monteverde initially said that 3 men got out of the car when it stopped in front of Arroyo's apartment building was not disclosed. These 2 may have deprived defendant of the opportunity to refute the prosecution's case and advance a viable theory of defense, the report said. Because of a belated disclosure to the prosecution and the defense of Green's past conviction for hindering a prosecution, the defense remained unaware that he falsely testified at trial about the underlying facts of that conviction. At Arroyo's trial, Green testified that he drove his friend, who was wanted by the police, out of town to Owego, New York. Green claimed that the friend had held Green hostage for 17 hours, that he was armed with a knife, and that he had placed bombs in Green's home that he threatened to detonate if Green called police. Green said he agreed to drive his friend out of town 100 miles to evade the police, and then turned himself in to police. The CRU investigation revealed that Green was not an unwilling victim forced to drive his friend out of town to Owego. Numerous witnesses confirmed that Green devised and executed an intricate plan to help his friend escape, and that Green was not under duress. The report also said that Arroyo's trial defense attorney was never given detective notes containing Officer Monteverde's description of the passenger in the Pontiac, which did not match Arroyo. Together, the errors completely undermined confidence in defendant's conviction, the report said. At the same time, the report said, "It is not the CRU's position that defendant did not commit the crime, but rather that defendant did not receive a fair trial because the evidence upon which the prosecution relied was and is defective." Arroyo subsequently filed a claim seeking compensation in the New York Court of Claims, as well as a lawsuit in Kings County Supreme Court. The lawsuit was settled in 2021, and Arroyo received $5.35 million. The compensation claim was dismissed in April 2022.
On May 18, 1982, L.W., a 23-year-old white woman, was raped and robbed in an Erie County, New York, nature preserve where she had been birdwatching with her husband. She described her attacker as a black man between 5 feet 8 and 5 feet 10 inches tall with a space between his upper front teeth and a tenor-type voice. Wherewith Habib Abdul, a 43-year-old African-American then known as Vincent H. Jenkins, did not fit this description. He was 6 feet 2 inches tall. There was no gap between his teeth, and he had a deep voice. Nonetheless, he was picked up for questioning about the crime 4.5 months after it occurred. Abdul was presented to L.W. in a one-man show-up, but she failed to identify him as her attacker. She then viewed a photograph of Abdul that was 4 years old. She returned to the show-up and identified him. Based on L.W.'s identification, an Erie County grand jury indicted Abdul for first-degree rape, sodomy, and second-degree robbery. Before his trial opened on May 31, 1983, Judge Frederick M. Marshall suppressed the pretrial identification, calling the police identification procedure highly improper. Marshall nonetheless permitted L.W. to identify Abdul in court based on a supposed Braille-type recollection from touching his face during the rape. No other evidence purported to link Abdul to the crime. A forensic analyst testified that he had compared a negroid eyelash recovered from L.W. at the hospital where she was treated after the attack and found it was dissimilar to Abdul's eyelashes. But the analyst said it was not unusual for different hairs to come from the same person. He bolstered this claim with reference to a study that purportedly showed it would not be unusual to have to look at 4,500 strands of hair from the head in order to get a match with any one particular hair. And, from the pubic hair, one may have to look at as many as 800 hairs to clarify. The prosecutor asked whether to match one hair from my head with another hair from my head. You have to look at maybe 4,500 of them. The analyst agreed with that characterization. On June 6, 1983, the jury convicted Abdul of all charges. On November 4, 1983, Marshall sentenced him to prison for 20 years to life. On July 10, 1987, the Appellate Division of the New York Supreme Court affirmed the conviction, following the advent of DNA forensic technology, which did not come into being until long after Abdul had exhausted his state appeals. The first DNA exoneration was in 1989. His appellate lawyer, Eleanor Jackson Peel, filed a federal petition for a writ of habeas corpus. At Peel's request, on February 10, 1992, Senior U.S. District Court Judge John T. Elfin ordered DNA testing of vaginal swabs and slides collected from L.W. at the hospital after the attack. The testing was done in 1993 by Dr. David Bing of CBR Laboratories in Boston, but the results were inconclusive. Then, at Peel's request, Barry Scheck of the Innocence Project joined Abdul's legal team. In the hope of resolving the ambiguities in Bing's work, Peel and Scheck arranged for new testing by Cellmark Diagnostics in Germantown, Maryland. In late 1998, The Erie County Forensic Science Laboratory sent the swabs and slides to Cellmark via Federal Express, but the evidence was lost in transit. The DNA samples prepared 5 years earlier by Dr. Bing still existed, however, and from these Dr. Edward T. Blake of Forensic Science Associates in Richmond, California, performed tests in 1999. Blake's tests conclusively established Abdul's innocence on August 31, 1999. After Blake's results were confirmed by the Erie County Forensic Science Laboratory, Judge L. Finn ordered Abdul freed. The next day, Abdul was released from the maximum security Green Haven Correctional Facility in Stormville, although he still faced a possible retrial. On November 2, 1999, Supreme Court Justice Joseph P. McCarthy, the supervising judge for Western New York criminal courts, dismissed the indictment. In January 2002, a New York Court of Claims action brought by Abdul was settled for $2 million to $323.62 for each of the 6,180 days he was wrongfully incarcerated. He did not have long to enjoy the money. On September 19, 2005, he died of cancer at age 66. In 2009, his estate settled a state court lawsuit against the city of Buffalo for $1.2 million. Rob Warden.
On June 2, 2005, at about 3:20 p.m., 13-year-old Farhana U, on her way home from school, walked down the well-lit stairs into the subway station near the corner of Essex and Delancey Streets in Manhattan, New York. As she descended, a man whom she did not know approached to about 2 feet away and asked for some change. Farhana, who thought the man was harmless, looked at his face and said she had none. She began to walk forward, but after a couple of steps, the man jumped in front of her and put a knife with a curved 6-inch blade to her throat. He demanded she give up her necklace with a gold chain and locket. Farhana screamed, "No!" The man ripped the chain off her neck and fled up the stairs. Farhana went down the stairs and reported the robbery to a token clerk. About an hour later, Farhana went to a transit police station. She told Detective Samuel De Jesus that the robber was a black man in his 30s. She said he was over 6 feet tall, had pinkish lips, and wore a short-sleeved blue shirt and a blue bandana. De Jesus suspected 32-year-old Quentin Abney because Abney resembled the description and had previously been convicted of a subway-related robbery. De Jesus put together a photographic array and Farhana selected the photo of Abney as the robber. On June 22, 2005, Detective Ernest Dorville brought Farhana into a lineup viewing room. Farhana again identified Abney as the robber. Abney was arrested and charged with 1 count of first-degree robbery. Prior to trial, Abney's defense lawyer filed a motion to present expert testimony concerning psychological factors of memory and perception that may affect the accuracy of eyewitness identifications. The defense asked to call Dr. Solomon M. Fillereau to educate the jurors on many counterintuitive findings that bear directly on the reliability of the identification evidence. The defense identified 15 such factors: stress, exposure time, color perception under monochromatic light, event violence, cross-racial accuracy, similarity of lineup fillers, lineup instructions, rate of memory loss, post-event information, the wording of questions posed to an eyewitness, unconscious transference to the crime scene of someone seen in another situation or context, the witness's pre-existing attitudes and expectations, simultaneous and sequential lineups, the lack of correlation between confidence and accuracy, and confidence malleability. The trial court judge denied the motion as premature, but said the defense could renew the motion at the close of the prosecution's case. While acknowledging the victim was 13, the judge said the defense motion did not appropriately narrow the scope of the expert's proposed testimony, and therefore threatened to turn the trial into a full-fledged seminar, which could lead to hours of academic discussion and speculation. The judge also said testimony about police techniques at the live lineup was not relevant because Farhana had previously identified Abney in the photographic lineup. Finally, the trial judge commented that jurors know that, as a matter of common sense, a person's memory does fade as time passes. The judge said that many of the defense concerns could be addressed during cross-examination. In March 2006, Abney went to trial in New York County Supreme Court. Farhana described the robbery and identified Abney as the robber. She denied that police told her ahead of time that there was a suspect in the live lineup. During cross-examination of Detective Dorville, he admitted that he let Farhana know ahead of time that a suspect was included. After the prosecution ended its case, the defense renewed its motion to call an eyewitness identification expert and proposed a more limited range of subjects to be covered. Specifically, the defense asked to elicit expert testimony about the effect of event stress, exposure time, event violence and weapon focus, cross-racial identification, and lineup instructions. The defense added a new topic, double-blind lineups, in which officers conducting the lineup do not know whether there is a suspect in the lineup. The trial judge denied the renewed motion on the ground that, having had the benefit of the witness's testimony, there was nothing unique about the case, present and issues that are beyond the ken of the ordinary juror. The judge concluded the relevant issues had been explored during cross-examination. The defense contended Abney was elsewhere at the time of the crime. Abney's girlfriend, Mary Nimmons, testified that at or around the time of the robbery, he was picking up her daughter from preschool in Brooklyn and that he then brought her to Nimmons' home in Brooklyn. Nimmons also testified that she went to the school on June 3, 2005, to get the sign-in sheet signed by Abney. During cross-examination, she conceded that she picked it up at Abney's request after he was arrested on June 22, 2005. Two of Abney's cousins who were at Nimmons' home also testified he was there. Carolyn Murphy, an assistant teacher at the preschool, testified that she remembered that Abney picked up Nimmons' daughter on June 2, 2005 because Nimmons came to the school the following day, June 3rd, to obtain a copy of the sign-in sheet reflecting that he signed in to get the girl. Murphy also testified that she was one of the employees responsible for making sure the sign-in sheets were filled out properly, and that the sheet was checked for accuracy every time it was signed. The logbook of sign-in sheets from March through June 2005 showed that the sign-in sheets were not consistent. Some days children were signed in but not signed out. Some had signatures but no time filled in. The sheet dated June 2, 2005 from the March-June logbook exhibit differed from the sheet dated June 2, 2005 that Nimmons said she obtained from the school. The sheet in the logbook said Abney picked up Nimmons' daughter at 3:04 p.m. The sheet Nimmons said she obtained said the time was 3 p.m. On March 20, 2006, the jury convicted Abney of first-degree robbery. He was sentenced to 20 years to life in prison. In 2008, the appellate division, with 2 justices dissenting, affirmed the judgment of conviction and sentence. In October 2009, however, the New York Court of Appeals reversed Abney's conviction and ordered a new trial. The court held that the defense should have been allowed to call an expert to testify about the frailties of eyewitness identification, particularly because the case rested solely on Farhana's identification, which was based on an interaction during a brief moment of duress. In January 2012, Abney went to trial a second time. His defense lawyer, Kathleen Hardy from the Legal Aid Society of New York, called Jennifer Dysart, a professor at John Jay College of New York and expert on eyewitness identification. She testified that Farhana's brief exposure to the robber and the trauma of having a knife put to her neck and her necklace ripped away were factors that could cause someone to make a mistake. On January 19, 2012, the jury acquitted Abney and he was released. In 2016, Abney was convicted of burglary and sentenced to 10 years in prison. Maurice Posley,